Got a question on TikTok asking about what are the steps for I guess a master tenant to evict a subtenant. You know, hi, my name is Rob Wells. I'm the landlord warrior on TikTok and YouTube. Please feel free to like, share, subscribe. Well, so I tell a lot of folks renting out places. I'll get questions about, hey, is the eviction process different to evict a subtenant, or is it faster? What do I have to do? The unfortunate news is evicting a subtenant involves the same steps as evicting someone, out of an entire rental unit. Okay, like you're renting out a room or something like that. There's no difference in the law about terminating the tenancy, whether you rent a room out, an entire house, a mansion, whatever it is. The process is still the same. And unfortunately, a lot of times people ask me, hey, is there a cost difference? And usually the answer is no, because you have to go through the same processes. Okay, you still have to issue a lawful notice to terminate the tenancy, whether that it's for just cause or not. If you get legal counsel, you're going to have to go through the same steps to make sure, hey, the tenancy is not subject to the Tenants Protection Act, just cause protections, meaning you have to have cause to evict a tenant under the civil code, and you still have to issue the termination notices. If you employ the services of a process server, they're going to charge you the same rates, and then the same processes in court have to be filed. So, for example, once your notice expires, you have the right to file an eviction or unlawful detainer action, and those processes are still the same. They don't change because you rented out a room or a space on your couch, basically, versus the whole house. You or your lawyer is going to have to go through the same process. You're going to have to serve the unlawful detainer complaint. You're going to have to still wait the requisite response time. Now it's 10 business days in California, excluding weekends and judicial holidays now. So that process is still the same. You still have to go to hearing as well. That's still the same. Nothing changes out of this, at least in the residential context. Okay, the rules are the same. You have to follow the same rules as if you are a regular landlord renting out an apartment or a house. You're less likely, if you're renting out rooms and you reside there, you're less likely to be subject to the Tenants Protection Act, but you might be subject to local eviction control if your city or county has passed regulations in your local area that further restrict terminating the tenancy. You might have to comply with that. So it really all depends. The first step, if you are a master tenant or you're renting out rooms to people in your home, that type of deal, the first step you should take is probably talk with legal counsel to figure out how you can terminate the tenancy, what are the problems, and they can kind of coach you on what you can do and how you should go about your case. Because some cases, for example, we had a lot of nuisance cases like the last couple of weeks here. You're going to have to document, okay? If not, you're not going to be successful in court, and you could just be spinning your wheels, just giving the lawyer just money, basically, and the lawyer can't really do anything for you because you don't have any evidence, that type of deal. So it's no good deed goes unpunished, as they say. And I understand renting out rooms and stuff because you're trying to offset your expenses. But you got to remember, too, if the deal goes sour, you're going to have to follow the same steps as a regular landlord would have to. And that's the unfortunate truth here. So if you're dealing with something like this, always good to talk with good legal counsel. If you're in the Northern California area, we might be able to help out. So feel free to reach out to us, and we might be able to help you out. If you got comments, questions, put them down below. Until next time, folks, I'll talk to you then. Thanks.